We have done so many stories, y'all, here about the constant attack on voting rights in this country, and not just the attack on black folks, the attack on young white voters, what's going on, Latinos and others. We see this happening all across this country, and we see this happening a lot in Georgia. In Georgia, a federal judge has declined to block several provisions of a recently passed law in Georgia, while there are various legal challenges to it. Now, you often see this, folks, where they will say, well, while these cases are going forward or appeals are being happening, then we're not going to stop things. We saw the same thing happen with the congressional districts. Even when the Supreme Court allowed these illegal districts to move forward, saying there wasn't enough time to redraw these lines. But the problem for the folks who are living there is that they're having to still abide by these restrictions that were passed 2 years ago in Georgia. Now, several groups are challenging what is called Senate Bill 202, claiming the new law is going to make it harder for blacks to vote in Georgia. But again, the judge ruled the plaintiffs failed to prove the legislation is intended to discriminate against voters based upon race. Provisions include limits on the number of absentee ballot drop boxes, an ID requirement for voters casting absentee ballots, a ban on volunteers providing food and water to voters waiting in line at the polls. Joining me is Caitlin May, a voting rights staff attorney at the ACLU of Georgia, coming out of Atlanta. Caitlin, glad to have you here. So here's this whole deal. Oh, well, we can't show that it's targeting people because of their race. Well, then, all of a sudden, the laws are created. All of a sudden, I wonder why. Is it because you had this massive increase in black voter turnout? And this is the problem that we have with a lot of these judges, where they want to say, oh, no, but you got to show like this exact evidence that it was directly because they are black.
That's right. Yeah. And thank you for having me. So Senate Bill 202, what we often call Georgia's anti-voter law, was passed in 2021, as you said, after a huge influx of turnout, even amidst COVID. And SB 202 was passed in response to a fear of voter fraud. And it's important that I say a fear of voter fraud because the advocates of this bill are not pointing to actual cases of voter fraud. They are pointing to election deniers who are afraid of that happening. Voter fraud in Georgia is not a large problem. Voter access in Georgia has always been and continues to be a huge problem. In this case, SB 202 made a lot of changes to our election code, and almost all of those changes made it harder for Georgians to access their right to vote, but in particular, made it harder for Black Georgians and Georgians with disabilities.
I'm sorry, go ahead.
So in this case, we moved for a preliminary injunction. Unfortunately, we just received word that the judge did not grant our preliminary injunction. So this is just a preliminary order. As you know, gone are the days when the legislators openly say we're passing this bill so that Black Georgians cannot vote. But that doesn't mean that these tactics are not targeted towards the methods of voting that Black Georgians use and voters with disabilities use. And so, as I said, this is just a preliminary ruling. We are still going to fight about this in the court and in the legislature, and we're going to continue to prepare for trial.
You know, one of the things that we talk about this stuff a lot on this show, and I don't think the people out there really understand the battles that are taking place in courtrooms nationwide. I mean, literally. Law being passed, lawsuit filed, law being passed in North Carolina, lawsuit filed, law passed in Florida, lawsuit filed. I mean, it's like, what we're talking about here is exactly what we saw during the Jim Crow days after the Brown versus Board of Education.
Yeah, it's like a hydra with many heads. As soon as you get a ruling on one issue, then there's another bill that's going to pop up. And like you said, it's all over the country. It's particularly all over the South. And SB 202 is a particularly egregious example because it was an omnibus election bill. It touched every part of our election code and made things harder for voters and made things harder for local county election administrators.
Questions from the panel. Michael, you first.
All right. Thanks for coming on today. When we look at some of the history of Georgia, we, in addition to this voter suppression, we look at things like the statewide runoff election rule that was championed by Denmark Groover, who was a white supremacist segregationist member of the state legislature in 1963. How do you, when we talk to especially African Americans about what's going on in Georgia and the voter suppression, how do we connect bills like this to a history of voter suppression in Georgia?
Yeah, I mean, I think any time that you have seen Black political power grow across the South, and particularly in Georgia, you've seen a reaction to that relatively quickly. And as I said, how open the legislature is about the reasons for that reaction has, changed over time. But we have expert testimony or expert reports that show that the methods that are targeted by laws like SB 202 are things like absentee voting. And those methods are used in particular by Georgians of color, Black Georgians, Latino Georgians, and Georgians with disabilities. And of course, youth voters as well. So
Right.
This is part of a long line of cases where the legislature restricts access to the ballot in reaction to Black Georgians turning out and exercising their right to vote. Unfortunately, this negative ruling for us is also part of a long history in Georgia. Black Georgians have shown for decades that they are willing to overcome many obstacles put in the way of their right to vote. And just because they are willing to overcome those obstacles and still have great turnout doesn't mean that those obstacles should be allowed to exist.
Matt?
Thank you.
Yeah, Caitlin, I have two questions, one of which is kind of a wonky lawyer question, so excuse me for that in advance. But I guess the two questions I have are first, as it relates to the provisional ballots, I saw that there is a prohibition on a provisional ballot that is cast in the wrong place. And I wanted to know how kind of you guys are framing that, because that seems to me to be pretty clearly violative if somebody goes through the checks at the appropriate place, casts the ballot, and they end up being in the wrong place. It seems like that's not their fault. That's the election administrator's fault. And I kind of want to see your position on that. And then the second question is, how are y'all handling the messaging? Because the difficult part of this seems like you almost need fewer Black people to show up in order to show there is, in fact, a disparate impact, but you can't, publicly advocate for that. So how are y'all handling the messaging part of this as it relates to the lawsuit?
Sure. Yeah. So as to your first question, that is the out-of-precinct voters. That is one of the many provisions of SB 202 that we are challenging. So that is unfortunately one of the provisions that we had hoped to have eliminated temporarily for the 2024 elections while we wait for trial. Unfortunately, that was not the result that we got, but we will continue to fight for that and hopefully have a long-term solution that changes that law back to what it was. And allows people to cast a provisional ballot at any time of day. SB 202 changed that law to only being after 5 p.m., so 5 to 7 p.m. on Election Day. And as to your second point, that's exactly right. Of course, we would never use any kind of messaging to ask people not to show up to vote. We always want high voter turnout, and Georgians have really turned out in the past couple of years, despite these restrictions on their access to the ballot. But, we just have to show the judge that just because people are willing to go to great lengths to exercise their right to vote doesn't mean that the restrictions are not unnecessarily hindering that access, and doesn't mean that those laws are just. So we have a coordinated, we call it integrated advocacy. We have a great policy and communications team. So all of us work together to simultaneously try to make sure individual Georgians are able to access their right to vote and do turn out to exercise their right to vote, but also challenging these laws so that in the future and long term, that's an easy thing to do, because it's not right now for many Georgians.
All right, then. Well, keep up the good fight, Caitlin. We appreciate it. Thanks a lot.
Thank you for having me.